attempt for to increase the child support obligation.
Defendant's objection to child care charges appearing at today's hearing via Zoom. There being no objections is plaintiff Emily Kroll with her attorney Melissa Umulis and defendant Mark Kroll with his attorney Jeffrey Norman. And Mr. Norman, you may proceed.
Thank you, Your Honor. Objection is based primarily on the following. First of all, there's a couple of provisions in the judgment of divorce that still remains in full force and effect. One of the provisions states it is further ordered that neither party shall seek a review of child support before April 30, 2025. The other provision that's relevant here is it is further ordered that if either party is unable to parent during his or her parenting time, and that inability includes 6 hours or more, the other parent will have the right of first refusal to parent the children during that time. Dr. Kroll was paying an agreed upon amount of $5,000 per month, and that's an upward deviation of about $1,600. Practically speaking, the objections are based on the following. This increases for child care costs. The plaintiff works from home. The children are 10 and 12 years old. The 12-year-old is old enough to babysit other children, and in fact does babysit other children. And when she's doing that, she's not even attending or present for this child care that they're requesting reimbursement for. And last, Dr. Kroll has people who are available to provide child care to these minor children if it's needed. So that's the basis of the objection, Your Honor. And that's all I have.
Is this a situation where is there a claim that the charges themselves are fraudulent in some way?
I don't think, not fraudulent, but just other than what I've stated, we're not even certain that the 12-year-old is present during this time and these charges are in fact being incurred. One thing we might seek down the road is an itemization of exactly how this child support is being spent, this $5,392 per month. So we don't know if those charges are actually being incurred.
Okay, thank you, Ms. Umulis.
Yes, the assertion that one of the children is not present during the times the nanny is there is absolutely not true. Both children are present while the nanny is providing care. In fact, my client is only utilizing the nanny 3 days per week. She's employed full-time with Blue Cross Blue Shield. She has an extremely demanding job. She works 5 days a week, but is presently only utilizing the child care 3 days a week due to Dr. Kroll's refusal to contribute to any of the costs. So really, my client could be utilizing child care 5 days per week, and it would be extremely helpful for her to do so given the demanding nature of her job. But she's not at this point just due to the historical refusal to contribute. And this nanny that my client is using is the party's long-term nanny that they had used all throughout their divorce and their marriage. She's actually been the nanny for the children since Elena was about 3 years old. And with the exception of, I think, 2 summers, they have used this nanny every summer for childcare. And so this isn't a new childcare provider. This is someone that Dr. Kroll obviously agreed was appropriate to care for the.
Notice the angle. Dad's side hints maybe these charges aren't even real, that Mum's nanny bills are inflated or unnecessary. Not outright fraud, but planting doubt. Classic courtroom tactic. If you can't kill the number, question the integrity of the expense. Would you buy this line of defense?
This does not apply because Dr. Kroll is also employed full-time and is not able to provide care during the work week. And we also have a temporary order in place right now. So that order is the order that controls. I'd just like to note, my client submitted this documentation to front of the court for the reimbursement. The fact that we're here arguing over $392 a month is, I'm shocked that we're here arguing over this. Dr. Kroll makes probably at least 4 times as much as my client. I'll just go through, for example, a list of expenses for these children that my client has borne the sole responsibility for since the divorce. 100% of the nanny costs for childcare last summer, which she didn't seek reimbursement for. The G-Tax tuition for the children for the 2021-22 school year in the amount of approximately $12,000 that Dr. Kroll refused to contribute to. School laptops for the kids, their cell phones and their cell phone plans, clothing, volleyball camp, which Dr. Kroll agreed to reimburse my client $80 for last summer and still has yet to reimburse her despite her.
This moment pulls back the curtain. Same nanny trusted for years, now turned into the lightning rod for financial war. Both parents once agreed she was perfect for the kids, so why is her role suddenly on trial? Is this really about childcare or control?